directly from the mind recall of a human being who knows exactly what happened and will swear to it under penalty of perjury. But that's irrelevant. No, we must find in favour of the corporation. What is it one judge said? The banking institution is paramount. Oh, this is the same judge, Tommy, down in Lewis. Right, okay, this case is between HSBC and Mr. Blah, blah, blah. Well, I suppose I should declare that I've got 9 grand worth of shares in HSBC, but I don't think it'll make any difference to my dividends, so I'll carry on anyway. And confidence in the banks is paramount. So I rubber stamp this order against Mr. whoever. Yes, it's the mindset, isn't it? Stone's Justices Manual, Section 132. Stone's Justices Manual is the thing that they proudly carry. It's got 3 sections and it's an enormous thing. It gets updated every year or whatever. First of all, Magistrates' Court jurisdiction. To try a summary offence, council tax is not a summary offence. For example, common assault. B. As examining magistrates over any offence committed by a person who appears or is brought before the court. In the case of council tax, no offence has been committed. It's a liability assessment hearing. They're trying to decide whether or not you actually should pay it. The fact you haven't paid it yet doesn't matter. What they've got to decide is whether you should. So liability hearing. Same, by the way, with business rate tax, same thing. Subject to section 18 to 22 of the Magistrates' Courts Act 1980, to try summary any offence which is triable either way. Council tax is not a summary offence. In the exercise of its powers under section 24 of the Magistrates' Courts Act 1980, to try summary an indictable offence. Council tax is a civil dispute. It is not an indictable offence like GBH or dangerous driving or rape. Magistrates' courts, which is where all the council tax hearings take place, have no jurisdiction according to their own manual. What are magistrates anyway? Well, they're a cost-cutting attempt to provide the functionality of a grand jury and to dispense so-called justice on the cheap and not cheerful. But grand juries do not dictate the outcome. They only decide whether or not a prima facie case has been made such that a full trial is warranted. That's the function of a grand jury. Now, magistrates attempt to be a jury of 3, which is nothing like good enough for even basic justice, and simply provides an opportunity for up to 3 would-be tyrants to perform their sadistic pleasures. You are not alone. This was an email I received, forwarded to me. It's hard to read it, I'll read it out. A guy called Bob, who called himself John, to remain anonymous, wrote to the Magistrates Association and said, do magistrates take an oath? Wrong question, we've already, been through that, but that's the question he asked. And someone called Leonora Ronell from the Magistrates Association wrote back to him saying, yes they do, and this is what it is. And she did a courtesy copy to someone called Barbara Tite, who it turns out is a records administrator for the Magistrates Association. And I don't know whether she did this deliberately or whether she didn't. She included a little section of internal email between her and her friend Barbara Tite. I don't know whether it was accidental or whether it wasn't. But this little bit of internal email is right down the bottom. The third line up from the top, from the bottom. She's forwarded the original request from John or Bob or whatever to Barbara Tite, and Barbara Tite replies, and another ... You're not alone. HMCS flagship, the Northampton Bulk Clearing Centre. Oh, what a wonderful place that is. More justice on the cheap. Unpaid demands from utility companies, policymen and local authorities will be sent there to be rubber stamped into warrants by deputy district judges. A deputy district judge is a solicitor who performs the rubber stamping role between 5 and 15 days a year. I will rubber stamp anything, including typographical errors, errors of substance, no account number. Oh yeah, somebody's making a claim and they haven't been properly counted on. Oh, that's all right, I'll rubber stamp that. There are many examples. It's quite obvious they don't read, nor do they consider. Let's face it, they're only solicitors after all. Anything. Hence it's a waste of time writing to them and arguing with them. Their so-called warrants amount to nothing more than toilet paper. If a bailiff calls, he will almost certainly be wielding one of these toilet paper warrants. Tell him to go and get signed confirmation that the secretary judge was acting under their oath of office at the time. It all comes back to that one, because that one, it puts them in a half Nelson, full Nelson. Orders, what are they? Well, in case you don't get it, judges and magistrates are continually arbitrating without consent, applying statutory obligations on you when you have not agreed or promised to be bound by them, expecting you to service their orders for free when no business supplies its major products for free. If they want to consider you to be a legal fiction person, i.e. a small corporation, then they should expect a bill from that corporation for servicing any orders they issue. Like all other businesses, no, I think yes. If a court orders stationery, it expects to pay the suppliers. And who sets the amount to charge? The supplier sets the amount. Whoever services the order sets how much it's going to cost. And the court staff shop around for the cheapest. That's normal, honourable business practice. Anything else is either blackmail, extortion, racketeering, fraud, or just plain old theft, whatever you want to call it. Policymen and servicemen and members of staff all get paid by their wages and salaries for servicing orders. No one services orders for free. That's what an order is. They don't like it if you tell them. What do you do with a bailiff? Well, they're morons and thugs, so the question really is, what do you do with a moron who's also a thug? Well, you never ever open the door under any circumstances, and I've had to deal with quite a few bailiffs in the last few years. Tell him he is a public servant, and as a member of the public you are therefore the master mistress, and you don't require his services. I mean, hey, who's that? Well, it's David Bailiff. I thought I sacked you lot last week. Didn't somebody call last week? No, I sacked you lot. Well, oh, well, it doesn't matter. Listen, Dave, don't require your services. Thanks very much. You're sacked. Now fuck off. Oh. Cheerio, Dave. Went downstairs, got in his car, was in the office, drove away. Bye, Dave. You don't require his services, and he thought he did, then he's sacked. As previously noted, tell him to go away and get the signatory judge to confirm in writing that they were acting under their oath of office at the time of signing the warrant. What do you do if a bailiff threatens to return with a policy man? Oh my God. Tell him the policy man will also be a public servant and that he will still remain the master and mistress. And will be perfectly happy and perfectly within your rights to sack the policy man as well. And keep sacking them until one does the job he or she is paid for. We'll come on to the police oath in a minute. Say you will demand to speak to superiors until this happens. This does tend to confuse these morons and thugs. It does confuse them because they... What? Oh. If you get bailiffs knocking